If you have been waiting for a real green card opening, stop scrolling and listen carefully, because May 2026 is one of those moments when understanding the rules correctly can make a major difference in your case. But let's be smart from the very beginning. This is not a magic green card giveaway, it is not an automatic approval, and it is not a shortcut that erases the law. What is happening right now is that the May 2026 Visa Bulletin and USCIS filing guidance have created real filing opportunities for many applicants. And if your category, country, and priority date line up, this may be the month to move immediately instead of waiting and losing valuable time. So in this script, I am going to break down exactly what the benefit is, who may qualify to act now, why apply today matters, what mistakes can destroy a good case, and how to check whether this month helps you or not. The first thing everyone needs to understand is that the real green card benefit in May 2026 is not one single new law. The real benefit is visa availability and filing eligibility under the official monthly system. USCIS has confirmed that for May 2026, family-sponsored applicants must use the dates for filing chart, while employment-based applicants must use the final action dates chart. That distinction is incredibly important because many people hear the Visa Bulletin moved, but they do not understand which chart actually controls their right to file with USCIS this month. If you use the wrong chart, you can misunderstand your eligibility, delay your case, or send the wrong message to your audience if you are creating content. So the real urgency comes from this. If the USCIS designated chart shows your priority date is current or earlier than the listed date, and you are otherwise eligible, this may be your opening to file Form I-485 now. Now let's talk about why people are calling this a huge benefit. Filing adjustment of status is not a small step. For eligible applicants inside the United States, filing Form I-485 can unlock major practical advantages. Depending on the case, filing can put you in a pending adjustment status, and it can also allow you to seek related benefits like employment authorization and advanced parole if available and appropriate for your category. More importantly, it moves you out of the stage of simply waiting in line with no active green card filing and into the stage where your permanent residence request is formally in process. That is why the phrase "apply today" matters. In immigration, timing is everything. A category can move forward 1 month and stall, retrogress, or become less favorable later. If your date is eligible this month and your case is ready, delay can cost you. USCIS itself explains that applicants may file when the relevant chart is current or when their priority date is earlier than the listed date. For family-based cases, May 2026 is especially important because USCIS says applicants must use the dates for filing chart, not the final action chart. That can be a major benefit because the dates for filing chart often allows some people to file earlier than the point at which a green card can actually be approved. In plain English, that means some families may be able to submit the adjustment package now, even if final approval may still come later. According to the USCIS May 2026 chart, the F2A category is listed as current for all countries in the dates for filing chart. That is a very big detail for spouses and unmarried children under 21 of lawful permanent residents who meet all the other requirements. Other family categories still have cutoffs, including F1, F2B, F3, and F4, and those dates vary by country. So this is not universal relief, but for the right person, the ability to file now is a real benefit that should not be ignored. Let's slow that down even more because this is where many people get confused. If you are in a family-sponsored category, you do not ask, "Did the bulletin move?" and stop there. You ask 3 separate questions. Number 1, what family category am I in? Number 2, what is my country of chargeability, usually based on country of birth? Number 3, what is my priority date, meaning the date the petition was properly filed? Then you compare that priority date to the USCIS designated dates for filing chart for May 2026. If your priority date is earlier than the listed date or the category is marked current, then you may be able to file your adjustment package if everything else is in order. This is why broad headlines can be dangerous. A headline saying, "Historic green card benefit," may be emotionally powerful, but the truth is always category-specific and country-specific. That is what the official USCIS page makes clear when it explains exactly how to use the chart and how to read current, unauthorized, and listed cutoff dates. For employment-based cases, the May 2026 benefit looks different because USCIS says employment applicants must use the final action dates chart this month. That means the question is not whether you can file under a more generous filing chart. Instead, the question is whether your category is current or your priority date is earlier than the final action cutoff date listed for your category and country. The May 2026 USCIS chart shows that EB1 is current for all chargeability areas except China and India, which both show April 1, 2023. EB2 is current for all chargeability areas except China, which shows September 1, 2021, and India, which shows July 15, 2014. EB3 shows June 1, 2024 for most countries, June 15, 2021 for China, November 15, 2013 for India, and August 1, 2023 for the Philippines. These are not small details. These dates decide whether many workers can take real action now or whether they still need to wait. One of the strongest parts of this May 2026 update is that several employment-based categories remain current or relatively favorable for many applicants outside the most backlogged countries. EB1 being current for many chargeability areas matters. EB2 being current for many chargeability areas matters. EB5 also has important openings, especially the set-aside categories, because the USCIS May 2026 chart lists the rural, high unemployment, and infrastructure set-aside categories as current across the board. That does not mean everyone qualifies. It means that people already in or pursuing those tracks need to pay attention right now. If your category is current and your paperwork is ready, waiting for a better month may not make sense. Immigration windows can close quickly. The Department of State also makes clear in the May 2026 Visa Bulletin that visa availability is governed by annual numerical limits, per-country limits, and category-specific demand, so movement is never guaranteed forever. Here is another key point for your script. The phrase historic benefit should be explained responsibly. If you present this as a brand new amnesty or an overnight rule change, you risk misleading people. A better and stronger script angle is this. May 2026 gives certain applicants a powerful, time-sensitive filing opportunity because USCIS has identified which visa bulletin charts can be used this month, and some categories are current or advanced enough for immediate action. That is the real benefit. It is historic for the people whose dates finally became eligible, for the families who can file under the family dates for filing chart, and for workers in categories that remain current or newly reachable. The Department of State says the bulletin reflects annual visa limits and category-based cutoffs, not universal open access. So the most trusted voice is the one that tells the audience the truth with urgency, not hype without facts. Now let's get into who should seriously check eligibility immediately. If you are the spouse or unmarried child under 21 of a lawful permanent resident and your case falls under F2A, this month deserves very close attention because the USCIS May 2026 dates for filing chart lists F2A as current. If you are in an employment-based category and your priority date is earlier than the final action cutoff for your country and preference category, this month may be your time to file or move forward. If you are in EB5 set-aside categories that are current, this is also a moment to review your case carefully. If you already have an approved immigrant petition or a pending petition that is expected to be approved soon, you need to line up your documents now instead of waiting until the last minute. In immigration, the people who benefit most from movement are usually the ones who already prepared before the window opened. At the same time, not everyone should rush blindly. This is where your script needs a clear warning. Being current on the chart is not the same as being automatically eligible to file. You still need the right immigrant category, the right petition foundation, the right immigration history, and compliance with adjustment of status rules. Some people may have unlawful presence issues, entry issues, status issues, inadmissibility concerns, or category-specific problems that make a same-day filing risky or impossible. The chart opens the door, but it does not erase the legal requirements behind the door. USCIS says applicants may file if their date is current or earlier than the listed date and if they are otherwise eligible. Those last words, otherwise eligible, matter more than many people realize. A rushed filing with missing evidence, wrong forms, or hidden inadmissibility issues can create serious damage instead of progress. Another part of the May 2026 reality that people must understand is that immigration review has not become easier overall. In fact, USCIS announced in March 2026 that it had strengthened screening and vetting for immigration benefits, describing stricter review practices, expanded checks, and more intensive scrutiny in certain contexts. That means this is not the month for sloppy filings, copy-paste evidence, fake documents, incomplete disclosures, or casual mistakes. If you want to benefit from a good visa bulletin month, you need a clean, organized, truthful package. Strong opportunity and strict screening now exist at the same time. That combination means serious applicants should move fast, but they should also move carefully. A good month can help you get in the line, but strict adjudication means the quality of the filing matters more than ever. That is why your call to action should not just be apply today. Your real call to action should be check your category, confirm your priority date, use the correct USCIS chart, verify full eligibility, and file fast if your case is truly ready. That is a smarter and more professional message. People lose time in two ways. Some wait too long because they never check the bulletin carefully. Others rush too hard, file the wrong thing, and create avoidable problems. The strongest script is the one that pushes urgency while protecting the audience from careless mistakes. That means telling them to review the USCIS chart for May 2026, confirm whether family or employment rules apply, match their chargeability area correctly, and compare their priority date exactly. One wrong assumption can change the entire analysis. Let's talk directly about the apply today psychology, because that phrase works only when you explain why same-month action matters. Visa bulletin movement is monthly. A category that is current now may not stay current forever. A filing chart that helps one group this month may change next month. Backlogs, demand, and annual visa numbers all affect how long an opening lasts. The Department of State explains that these categories are controlled by annual numerical limits and per-country limits, and when demand exceeds supply, cutoffs are used. In other words, delay is not neutral. Delay can mean missing an opportunity that was available this month. That is why anyone with a potentially eligible case should not just celebrate a headline. They should use the headline as a trigger to check their real case facts immediately. There is also an important credibility point you can include in the script. A lot of content online is using dramatic phrases like new immigration law just passed, secret green card loophole, or automatic benefit for everyone. But the official sources tell a more precise story. The May 2026 Visa Bulletin is a real update. USCIS chart guidance for May 2026 is real. Filing opportunities based on category and priority date are real, but the government's own language describes a regulated system of cutoffs, current categories, and eligibility rules. If you want your audience to trust you, tell them that this is a real opportunity, but it is not a fantasy. It is a timing benefit inside the legal system. That message is stronger because it respects the audience and protects them from false hope. You should also address cost and paperwork readiness, because many applicants hear "file now" and only later realize they are not practically ready. Filing an adjustment package is document-heavy. People may need identity documents, civil documents, medical examinations if required at filing, proof of lawful entry when applicable, financial sponsorship materials in family cases, job-related evidence in employment cases, and category-specific supporting forms. USCIS also has its own fee structure, and while the FY 2026 inflation notice specifically covers certain HR1 immigration-related fees such as asylum, TPS, parole-related items, and some EAD-related fees, applicants should always verify the current fee requirements for their exact forms before filing anything. The bigger message is simple. Eligibility without preparation still leads to delay. The people who win in a month like this are the ones who prepare documents now, not the ones who wait until the month is almost over. Another excellent point for this script is that family-based and employment-based applicants should not copy each other's advice. This is one of the biggest mistakes online. A family-based applicant may hear employment-based advice about final action dates and get confused. An employment-based applicant may hear family-based advice about dates for filing and assume they can file too. But USCIS already settled this for May 2026. Family-sponsored applicants use the dates for filing chart, and employment-based applicants use the final action dates chart. That difference changes everything. It changes whether you can file this month, whether you must wait, and how you explain the update to others. So the safest message is this: same month, same bulletin. Different chart rules depending on the immigrant category. If you want to make the middle of your script especially powerful, speak directly to the viewers who have been stuck in the system. Tell them this is the month to stop relying on rumors and start relying on their own priority date. Tell them this is the month to stop forwarding random social media clips and start checking the official USCIS page. Tell them this is the month to stop assuming they are not eligible just because they have been waiting for years. Some people wait so long that they stop checking seriously, and then a favorable month passes them by. The real breakthrough is not emotional excitement alone. The real breakthrough is matching your category, country, and priority date to the official May 2026 rule. That one discipline can turn noise into action. This is also the right moment to say clearly that current is one of the most important words in immigration. On the charts, current means numbers are authorized for issuance to all qualified applicants in that category and chargeability area. But that does not remove the need to qualify. And when a date is listed instead of current, only applicants with a priority date earlier than that listed date can move forward under the relevant chart. The Department of State states plainly that these categories are managed with dates, current markings, and unauthorized markings. So if your audience remembers one rule from this entire script, let it be this. Do not rely on the headline alone, rely on the chart language itself. You can also strengthen the ending by speaking to urgency without panic. Say this clearly. If your date is eligible and your case is ready, acting now is smart. If your case is not ready, then today is still the day to start getting ready. Request the documents, review the forms, confirm the category, check your petition status, fix inconsistencies, make sure names, dates, prior addresses, and prior filings are accurate. If you need legal guidance because of prior violations, unlawful presence, criminal issues, or complex immigration history, do not hide from those issues. Deal with them before filing. The best month in the visa bulletin cannot rescue a weak or inaccurate filing, but a well-prepared applicant can turn a favorable month into real progress toward permanent residence. So here is the message of May 2026 in plain English. The opportunity is real, but it is specific. For family-sponsored cases, USCIS says use the dates for filing chart. For employment-based cases, USCIS says use the final action dates chart. Some categories are current, some have advanced dates. F2A is current on the family filing chart. Several employment-based categories are current for many chargeability areas. EB5 set-asides are current, but all of this sits inside a system of category rules, annual limits, country limits, and eligibility requirements. That means the right person may truly need to apply today, while another person may still need to wait. The power of this month is not hype. The power of this month is precision. And let me close this script with the strongest possible reminder. If you have a pending or approved family or employment petition, if you know your priority date, and if you have been waiting for your window, May 2026 is not a month to ignore. Check the official USCIS filing chart today. Check the May 2026 Visa Bulletin today. Match your priority date carefully. If your category is eligible and you are otherwise qualified, move now with discipline and accuracy. Do not let confusion, rumors, or delay steal a month that could move your future forward. This is not about false promises. This is about real immigration timing, real filing opportunities, and real consequences for people who are ready. May 2026 may not be a benefit for everyone, but for the right applicant, it can absolutely be the month that changes everything.